Welcome to the August 2024 edition of This Month in Payroll. I'm Claire Soccio, a partner in PwC's Payroll Advisory and Operations practice. This month we will focus on the new definition and conversion process for casual employment, the new distinction between employee and independent contractor, revised ATO guidance about superannuation for independent contractors, and lessons from a recent Victorian long service leave decision. Effective the 26th of August 2024, two closing loopholes amendments to the Fair Work Act came into force, both of which have a significant impact for payroll functions. Firstly, there's a new statutory definition of casual employment, which now assesses the totality of the relationship over time. This is a change to the previous approach, which focused on the terms of the contractor arrangement at the time the offer was made. Under the new definition, casual employment now exists where there is no firm advance commitment to continuing and indefinite work, and the employee is entitled to a casual loading or a specific casual rate of pay under an award, enterprise agreement, or employment contract. Put simply, the changes mean that it's not just the language of the initial contract or another single factor that determines whether casual employment exists. Rather, employers need to consider the real substance, practical reality, and true nature of the employment relationship over time. So when assessing if a worker is a casual, the factors and conduct that should be considered include whether the employer can offer or not offer work to the employee, and whether this is actually happening in practice. The employee can accept or reject work, whether it's reasonably likely there will be future work available in the business. There are permanent full-time or permanent part-time employees in the business performing the same kind of work as the casual, and whether the employee has a regular pattern of work. Once the definition of casual employment is met, the employee will remain a casual until their status changes. This might happen by the employee accepting a new employment offer with different terms, by the employee requesting conversion to permanent employment under the new conversion process, which we'll discuss in a moment, or by an order of the Fair Work Commission. This new definition only applies to employees who are employed or whose employment circumstances change on or after the 26th of August 2024. Employees who were classified as a casual before that date will remain a casual under the previous definition unless they move to permanent employment. As highlighted, the process for conversion from casual to permanent employment has also changed. The new process shifts the burden from the employer, who previously had to offer conversion to eligible employees, to the employee. Under the new rules, a casual employee employed on or after the 26th of August can, after 6 months of employment, or 12 months in a small business, issue a written notification to their employer requesting a change to permanent employment. This may happen, for example, if they have assumed a pattern of ongoing and regular work. Employers have to consider such requests and respond in writing within 21 days to confirm the terms of the acceptance or the rationale for denial. Reasons for denial may include fair and reasonable operational grounds, such as substantial changes to the resourcing needs or operation of the business. The new process means that employers no longer have the onus of reviewing long-term casuals and extending offers of conversion to permanent employment. They do, however, still need processes in place to ensure each employee's contract accurately reflects their employment status and is consistent with actual conduct under that contract. That employees' requests for conversion are considered and responded to within the required time limit, and that the casual employment information statement is issued to relevant employees on commencement and again after 6 and each further 12 months of employment. Different timeframes apply to small businesses. Employers should also make sure that they've met any residual obligations under the prior rules, including making offers of conversion to eligible casuals. For casuals employed before the 26th of August, the previous conversion regime will continue to apply for 6 months from that date, or for 12 months for small businesses, and the new regime will then apply thereafter. There is also a new and expanded test in the Fair Work Act, which, for the first time, provides statutory clarity about the often complex distinction between an employee and an independent contractor. There are some similarities to the new rules for casual employees. From the 26th of August, an employer assessing whether a worker is an employee or an independent contractor must also consider the real substance, practical reality, and true nature of the relationship. Once again, this means monitoring and regularly reassessing the totality of that working relationship, including both the terms of the contract and conduct of the parties across its duration, to identify any contracts being performed or delivered in a way that creates an employment relationship. Some of the relevant indicators to be considered together include the amount of control over how work is performed, which party has financial responsibility and risk for the output, who supplies the tools and equipment, the ability to delegate or subcontract the work, freedom over the hours of work, and the expectation of work continuing. Getting this categorisation right is crucial because employees and independent contractors have different legal rights, protections, and entitlements, including minimum wages and leave. Note that a carve-out is available for certain contractors who earn above a high income threshold. For FY25, this threshold is $175,000 and will allow eligible high-income contractors the right to opt out of the employee-employer definition, subject to a detailed notification process. Continuing with the theme of independent contractors, but shifting the focus slightly, the new definition we've just discussed is relevant for the purpose of the Fair Work Act only. Employers need to separately consider relevant legislation and guidance and make sure they meet all tax, superannuation, workers' compensation, and long service leave obligations for independent contractors. To that end, the ATO has released a draft update to Taxation Ruling TR 2023/4, which provides specific guidance about income tax withholding and superannuation guarantee for employees and independent contractors. The draft update revises the original ruling to bring together the legislation and common law interpretation established in recent court decisions. Superannuation guarantee legislation deems an independent contractor to be an employee for SG purposes and therefore requires SG contributions to be made if the contractor works under a contract that is wholly or principally for the labour of the person. The new draft ruling provides supporting guidance for this definition that replicates the three criteria established in recent decisions, including Moffat and Jamsek. Firstly, there must be a contract, being a bilateral exchange of promises of labour on one side and of payment on the other. Secondly, the person must work under the contract. The draft ruling specifies that this only includes natural persons. So independent contractors engaged through interposed entity structures, such as partnerships, personal services trusts, and companies, cannot be an employee for SG purposes. And thirdly, the contract must be wholly or principally for the labour of the person themselves. This can't be the case where the person has a right to delegate, subcontract, or assign the work under the contract, where the contract is for a result, or where the contract is principally for the provision of equipment or other non-labour components. The draft ruling also provides revised guidance about SG obligations for entertainers, musicians, promoters, and similar contractors. In the modern business context, superannuation may be payable for a guest speaker at a conference, a celebrity or social media influencer that promotes products or services, or even a DJ or performer hired for a corporate event. The draft ruling requires that each payment to such providers is separately examined and the resulting superannuation obligation assessed on a payment-by-payment basis. The draft ruling is open for public consultation until the 31st of August 2024. However, significant changes are not anticipated. So what are the key takeaways for employers? With the new definition of employment under the Closing Loopholes Amendments and the new guidance in this draft tax ruling, organisations need to refresh the governance and processes in place to manage independent contractor arrangements. There should be clear delineation between the definitions and the resulting obligations under the Fair Work Act for minimum wages, entitlements and protections, and those under other legislation setting out tax, superannuation and other entitlements. It is possible that contractor obligations are managed by different departments, which may include accounts payable, payroll, and tax. Clarifying and documenting the respective roles and accountabilities of each department is critical to ensure that these relationships are reviewed regularly and that all obligations are satisfied. And now to our final topic. In late July 2024, two subsidiaries of the Commonwealth Bank, CommSec and Bankwest, pleaded guilty to criminal offences brought by the Wage Inspectorate of Victoria in relation to non-compliance with Victorian long service leave obligations for select former employees. Recognising the early guilty plea and no prior convictions, the magistrate did not record a conviction and imposed relatively modest fines of $18,000 plus costs on each of the two businesses. These penalties aren't significant for businesses of this size, so why do we raise this matter? This case stemmed from the late payout of long service leave to terminating employees. Under the Victorian legislation, employers have to pay out accrued long service leave entitlements to eligible terminating employees on the day their employment ends. Failure to do this leads to a maximum penalty of 60 penalty units, which is currently $10,904 for each day from the date of termination until the date long service leave is paid out. This time frame is challenging for payroll teams to meet, especially when it takes time to compile the data and calculate the accurate entitlement, or when terminations occur quickly or with very short notice from the business to payroll. In a lesson for all employers, Magistrate Fawcett noted in her judgment that inadvertence, system failures and complexity in long service leave rules are not an appropriate excuse for failing to pay correct employee entitlements. The Wage Inspectorate Victoria Commissioner, Robert Hortle, also commented on this case, stating that boardrooms across the nation should be asking questions about their long service leave obligations and governance, given some of Australia's biggest companies have now fallen foul of these laws. So this matter provides a timely reminder for all employers to review the processes and resources in place to allow payroll teams to calculate, process and pay entitlements both correctly and within the necessary timeframes. And that's it for our August edition of This Month in Payroll. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC contact. Until next time, have a great month in payroll.